It literally says, all in capital letters, I eat. It's about 5 to 6 inch letters, bold, capitalized, in white letters on the back window. It takes it's as big as this third brake light.
In May of 2019, Florida man Dylan Shane Webb was pulled over by Columbia County Sheriff's Deputy Travis English, who objected to the sticker on the back window of Webb's truck, which said, in all capital letters, I eat ASS. Deputy English ordered Webb to remove one of the letters during the traffic stop. Webb refused, citing his First Amendment rights, but he was arrested and booked in jail for obscene writing on vehicle and resisting an officer without violence. Did Webb have a First Amendment right to have that sticker? Was the arrest unconstitutional? What happened to the criminal charges? Was there a lawsuit? If so, was it successful? You might be surprised. As someone out there in the public as a content creator and a lawyer, I want to make sure that my personal information isn't out there floating around on the web. If you didn't know, your personal information is being bought and sold online. Privacy has always been a concern for me, which is why I now use Incogni, who is today's sponsor. You know, the other day my personal cell phone rings and I answered it, and it's just some stranger. I asked how he got my phone number, and he said he found it online, along with a lot more information, such as my home address and information about my relatives. Another time I signed up for a store loyalty card, and then a few days later started receiving spam in my mailbox and spam phone calls. After signing up for Incogni, I discovered that there were 78 data brokers that potentially had my private information. I had never heard of most of these companies, but they had definitely heard of me. Incogni forces these companies to delete your data. There are laws that allow you to do this, but if you want to do it yourself, you'd have to figure out the applicable laws, write letters in a specific legal way, and follow up to make sure that your instructions are followed. Even if you had the legal expertise like I do, it would be incredibly time-consuming. But Incogni handles this for you. The same day I signed up, Incogni had already gotten my private details removed from 3 of these data brokers, with 71 more in progress, and I didn't have to do anything after signing up. So check out Incogni using the link below, or go to incogni.com/civil to get an exclusive 60% off an annual Incogni plan. Again, check out Incogni using the link below, or go to incogni.com/civil to get an exclusive 60% off an annual Incogni plan. Now back to the video. On May 5th of 2019, Dylan was driving his vehicle in Columbia County, Florida. Deputy English pulled up behind him at a stoplight and noticed the sticker. The deputy testified that he stopped Webb's vehicle because he believed that the sticker was obscene in violation of Florida statutes section 847.011.
1026. Pretty pulling into Columbia glass tent. What's going on, gentlemen? My name's Deputy English. Hey man, the reason I'm pulling you over is your derogatory sticker on the back of your truck. What is that? How's it not derogatory?
It's words.
It's words, okay. What does those words mean?
It's ass and eat.
I eat ass, okay? So some 10-year-old little kid sitting in the passenger seat of his mama's vehicle looks over and reads that I eat ass and asks his mom what it means. How's she gonna explain that?
That's the parents' job, not my job.
Okay, let me see your driver's license and your registration. Sir, you got ID on you also? You got anything illegal inside the vehicle, sir? Any drugs, guns, or knives? Large amounts of U.S. currency, dead bodies, or hand grenades? All right, hang tight for me.
After speaking with Webb, Deputy English returned to his patrol vehicle to run Webb's information. When he returned to Webb's vehicle, Deputy English asked Webb to step out and consent to a pat-down search of his person. Webb consented, and Deputy English performed the pat-down search. Deputy English then explained his reason for the traffic stop and issued Webb a notice to appear in court, which Webb signed.
Mr. Webb, step out of your vehicle, please. Do you have any weapons on you?
No, sir.
Step out. Can I check you for weapons? Turn around.
Is there a problem with the truck?
What's that?
Is there a problem with everything?
Is there a problem? Yeah. I'm gonna explain it to you. Step back here. We're in front of my patrol car. Here's your driver's license back. Here's your buddy's ID back. All right. Here's your proof of insurance and your registration. Okay. Listen to me. What you have on the back of your window, okay, is a misdemeanor in the state of Florida. Okay. I have 4 kids. A 14-year-old, a 10-year-old, a 6-year-old, and a 4-month-old. If my 6-year-old was to look at me and be like, Dad, what does IE ass mean? Okay. I'd be furious. All right. And the way that we handled this situation, okay, I'm not pleased with. So what I did is I issued you a court date, all right? So you can go explain it to the Columbia County court system.
Okay.
All right. So what I need you to do, I need you to sign right here, all right? This isn't saying that you're guilty, it's just saying the fact that I gave you a copy of your notice to appear, okay? You're gonna have a court date. It's gonna be on May 23rd. At 8 o'clock.
May 23rd. Was that a Monday?
Deputy English then directed Webb to remove one of the letters from the sticker so that it would no longer be obscene, in his opinion. Webb refused, citing the right to free speech under the First Amendment.
All right, sir. And this is my copy. This is your copy. I'm gonna have you take off one of those letters so that the word.
You're not infringing my First Amendment right. You're not doing that. I'm gonna need a copy of your ID too.
It's all on that ticket right there. Right. So, all right, hang tight right there for me then.
Prior to making the arrest, Deputy English returned to his patrol vehicle and called his supervisor, Corporal Chad Kirby, with the Columbia County Sheriff's Office. The two then discussed Section 847.011 and whether Webb's sticker violated the obscenity law.
Yep. Hey, so I pull this Mr. Dylan Webb over because he has a statement on the back of his truck that says IE ass. Okay. It's a misdemeanor in the state of Florida. All right. I issue him a notice to appear. I asked them to take one of the letters off so that it is no longer derogatory, and he is refusing. Is that not resisting? I'm charging him with obscene writing on a vehicle. It says, except as provided in paragraph 1 Charlie, a person who knowingly has in his or her possession, custody, or control any obscene book, magazine, periodical, pamphlet, newspaper, comic book, story paper, written or printed story or article, writing paper, card, picture, drawing, photograph, motion picture, film, any sticker, decal, emblem, or other device attached to a motor vehicle containing obscene descriptions, photographs, or depictions, any figure, image, photograph, record, wire, tape, recording, any written character, goes on, or any, or perpetrating to be for an obscene use or purpose without the intent to sell, lend, give away, distribute, transmit, show, transmute, or advertise the same, commits a misdemeanor of the 2nd degree. No, it's a misdemeanor. Like it's in the quick reference guide, but it's not a citation. Like when you go to issue a citation for it, it won't let you issue a citation. So I did.
What's the statute number?
847.011 subsection 2.
It says I eat ass.
It literally says, all in capital letters, I eat ass.
Okay, how is it, like covering the entire windshield? Is it small?
It's about 5 to 6 inch letters, bold, capitalized, in white letters on the back window. It takes it's as big as this third brake light.
All right, make sure you take pictures of all of that.
Yeah, I already got the pictures.
Arrest him, take him to jail, tow his shit. That way you can get it off the road. You know what I'm saying?
Okay. And then what do I do for the notice to appear? Do I just change it to a warrant affidavit and then request?
You still have it there, so change it from citation to arrest report. Use
Okay.
the same number.
Yeah, well, I haven't transmitted it yet, so.
That's what I'm saying. Change it to an arrest report, and then you can do from the arrest report back to the offense report.
Okay.
And just narrate in there.
Section 847.0112 makes it a misdemeanor offense to possess, quote, any sticker, decal, emblem, or other device attached to a motor vehicle containing obscene descriptions, photographs, or depictions. Florida law further defines obscene as material which, A, the average person applying contemporary standards would find, taken as a whole, appeals to the prurient interest, which means sort of sexual interest, depicts or describes in a patently offensive way sexual conduct as specifically defined herein, and C, taken as a whole, lacks serious literary, artistic, political, or scientific value. That's Florida Statute 847.001, subsection 10, and that basically tracks Supreme Court case law. The two also discussed whether Webb's refusal to remove one of the letters from the sticker constituted a separate offense of resisting without violence under Florida law. Under Section 843.02 of the Florida statutes, whoever shall resist, obstruct, or oppose any officer in the lawful execution of any legal duty without offering or doing violence to the person of the officer shall be guilty of a misdemeanor of the first degree. The conversation between Deputy English and Corporal Kirby ended in agreement that the proper course of action was to arrest Shane Webb and tow his vehicle. Deputy English then arrested Webb and placed him in the patrol vehicle. He then performed a search of the vehicle, which revealed no contraband.
All right, Mr. Webb, let me see your hands. Place your hands behind your back.
For what?
Place your hands behind your back.
For what?
Because you're going to jail, son.
For what? For what?
Because I gave you the option to take that off your window, okay? That is a violation of a Florida state statute, and it is a misdemeanor, okay?
What misdemeanor?
And then I asked you to take it off, and you refused. So step back here.
You want me to get my phone now?
No, you're going to step back here. Have a seat. Is there anything illegal inside the vehicle?
You're not searching it.
Okay, I am searching it because I'm towing it. Get inside the vehicle.
A tow truck removed the vehicle from the scene and towed it a short distance away to a parking lot where Webb's mother, Corporal Kirby, and the tow truck driver resolved to have the vehicle released to her for $225.
Yes, ma'am. Okay, your son's going to jail. So he has these obscene words on the back of his truck that says IES.
Okay.
I wrote him a notice to appear so that he could go explain it to a judge.
Okay.
I gave him the opportunity to remove one of the letters so that it was no longer obscene. Okay, he refused.
Okay.
And whenever I asked him to do it, he was resisting, and so he's getting charged with obscene writing on a vehicle and resisting.
Meanwhile, Deputy English transported Webb to the Columbia County Detention Facility, where he was processed and strip searched. He was incarcerated for little more than an hour and forced to pay $250 to a bail bondsman and a $15 jail fee. The state attorney's office for the 3rd Judicial Circuit ultimately determined that Webb had a valid defense to the charges under the First Amendment, and as such dropped both charges against him. On August 21st of 2019, Webb filed a federal civil rights lawsuit against the individual officers involved in the arrest. But on September 23rd of 2021, the federal court issued a memorandum opinion granting qualified immunity to the officers. Why? Well, if the sticker depicted a sexual act, it would be protected under the First Amendment, only if it has serious literary, artistic, political, or scientific value. That's Miller versus California from 1973. However, in such an instance, Deputy English and Corporal Kirby had to make a value judgment on the spot of whether the sticker had such serious literary, artistic, political, or scientific value when they decided whether or not to arrest Webb. Here, Deputy English and Corporal Kirby's determination that the sticker lacked such serious value under Florida law was not inherently unreasonable under the circumstances the court held. As such, the court found that reasonable officers in the same circumstances and with the same knowledge as English and Kirby had at the time could believe that Webb's sticker was obscene, making it an arrestable offense under Florida law 847.011. Then, because the court found that Webb's arrest was arguably justified under Florida's obscenity law, the court did not need to separately address whether the arrest for resisting without violence was unconstitutional, since arguable probable cause for any offense would bar Webb's false arrest claim on all charges. Likewise, qualified immunity was granted on the First Amendment retaliation claim because there was no Supreme Court or 11th Circuit case that was analogous to this one in the facts. There are some other cases out there with swear words being protected under the First Amendment, but none where the allegation pertained to words which were arguably sexual in nature, like this one, which the plaintiff did admit at several times during his interview. There was a 2019 Supreme Court case that could have saved this lawsuit on the grounds that the cops don't normally arrest people for the obscene sticker statute, and they just did so here because they were retaliating against Webb's protected speech. However, the judge in this case held that that case was too recent to the Webb incident, and that therefore that holding wasn't clearly established under the law, so qualified immunity was granted. So the answer is no. We know for a fact, having essentially time traveled, that the lawsuit was not successful and that the police officers were granted qualified immunity. However, that doesn't mean that if they did it again that the results would be the same. Just because qualified immunity was granted does not mean that the First Amendment was not violated. It just means that there was not a prior sufficiently similar case before this one occurred. The prosecutors were right that there was a successful First Amendment defense to prosecution. But that's not the same thing as a successful lawsuit because of the judicial activism that is the doctrine of qualified immunity. But if you're in Florida and you really want an I EAT ASS sticker on your truck, you may get a different result now in 2023, since the right to do so may now be clearly established, at least a judge could find. Maybe, who knows? As always, thanks for watching. Please subscribe. We're almost over 400,000 subscribers, and I really appreciate it. Also, follow me on the blog at thecivilrightslawyer.com, as well as the other social media sites, all linked in the description. Remember, Deputy English, freedom is scary. Sometimes there's lawful stuff out there that you don't want your kid to see. Deal with it, just like the rest of us who do not get to arrest people for seeing things that offend us.